Hi students, I'm back again with another video lecture. This lecture is on the Unit 7. Unit 7 is self-incrimination. Unit 7 will be covered week 11, which is on testimonial self-incrimination based on the Fifth Amendment to the United States Constitution. And week 12 has to do with a bodily self-incrimination, which is under the Fourth Amendment to the U.S. Constitution. So I want to talk to you in this video lecture on testimonial self-incrimination. So again, the source of protection is the Fifth and 14th Amendments, which provide that no person shall be compelled in any criminal case to be a witness against himself. This has been expanded to protect a person in all legal proceedings, judicial, administrative, formal, informal, criminal, and civil. Your author breaks down this into two degrees of protection: absolute protection and conditional protection. Absolute protection, the absolute protection to remain silent and not to incriminate yourself occurs two different points. One is your custodial interrogation, which we covered under Miranda, custodial interrogation. And the second point is at trial. And I'll talk to you more about that in just a moment. Conditional protection occurs where a witness may be forced to appear and testify, but then have the privilege to refuse to testify if the answer to the questions may incriminate them. So there's two different types of or degrees of protection. There's the absolute protection, which occurs at a custodial interrogation and trial, and then conditional protection for a witness when they're subpoenaed to testify and can refuse to answer questions that tend to incriminate them. There's three requirements for this protection. One, it has to be testimonial. Two, it has to be compelled by the government. And then, of course, it has to be self-incriminating. Let me talk about each of these prerequisites. First of all, testimony. What does testimony mean? Well, it's a lot broader than you may think. Testimony means a statement or behavior which explicitly or implicitly makes a statement or discloses information. There's a couple cases I'll talk to you about. One is Schmerber. Schmerber was a case where the person was arrested for driving under the influence of alcohol and or a drug. They actually drew blood from this person and submitted it to a lab to determine the alcoholic content and drug content of his blood. He was charged. He made a motion to suppress. He made a motion to suppress on two grounds. One is a violation of his privilege against self-incrimination under the Fifth Amendment, and then there was a motion to suppress illegal search and seizure based on the Fourth Amendment. I'm not going to talk to you about the Fourth Amendment. I'm going to talk to you about the Fifth Amendment. So under the Fifth Amendment, you're protected from testimonial self-incrimination. And Schmerber was drawing of his blood and submitting his blood to a lab for testing to determine alcohol and drug content. Was that testimonial? No, absolutely not. The court said no, this is merely a scientific test. It has nothing to do with testimony, and they denied his motion to suppress based on the Fifth Amendment grounds of privilege against self-incrimination. Compare that case to the Hubble case. Hubble was a well-known figure. He was related to the Clintons. He was involved in politics, held some powerful positions. And in the Hubble case, there was the federal authorities, I believe, they were investigating him for some wrongdoing, and they issued a subpoena duces tecum. I'm going to sidetrack for just a moment, and I want to talk to you about subpoenas. There's really two types of subpoenas. There's a subpoena ad testificatum, which we just call a subpoena, and that's just to appear and testify. There's this other type of subpoena called a subpoena ducis tecum, which means that you're not only to come, but you're to bring documents. So he was served with a subpoena ducis tecum to provide documents to the federal government for their investigation. And he challenged the subpoena and said this violated his Fifth Amendment privilege against self-incrimination. And the issue before the court was whether or not him providing the documents, so he's providing documents, was considered testimony, and therefore he had the privilege against self-incrimination. Did it apply? So what do you think the court said? Is production of documents testimonial? Well, the court said yes. The court said the fact that he had to hand over these documents actually made a statement. The statement, it's an implied statement, implicitly made a statement that he was the owner of the documents. He was the person who created the documents. He was the custodian of these documents. And that statement that behavior of him handing over the documents made those statements, and those statements were privileged under the Fifth Amendment. So testimony is not just about a person that's subpoenaed and testifying under oath in a court, for example, but it's a little bit broader than that. It includes behavior such as the behavior that you have or will read about in the Hubble case. So that's the first requirement. It has to be testimonial. Secondly, it has to be compelled. Now, compelled means to force or pressure a person to testify. And it'll include subpoena, threatened job loss, threat or use of physical harm, or custodial interrogation. So it has to be compelled. It's compelled by the government. Generally, the way the government compels someone to testify is by, handing them a subpoena. It can also be compelled against that person when they're in custody during interrogation. It can be compelled by threatened force. So it might be, an officer threatening. Maybe it's a witness. They're compelling testimony, and they're trying to get this person to incriminate themselves, or a threatened job loss. Say the officer, there's a police officer involved in wrongdoing on the job, and they order him to make a statement. So it's testimony is compelled. It's compelled because if he doesn't make the statement, they're going to fire him, and he's going to incriminate himself. So compulsion has to be compelled, but usually it's the situation is going to be a subpoena or a situation where there's custodial interrogation. So it has to be those three components. They have to be met. It has to be testimony, has to be compelled, and it has to be incriminating. So if they're asking a person their name or some other generic, non-incriminating type of question, a person cannot claim protection under the Fifth Amendment. So are there exceptions to this, to the privilege against self-incrimination? Yes. For example, general booking questions. If you're arrested and taken to the jail, believe me, they're going to ask you questions. Your name, address, date of birth, phone, social security number, driver's license number, your physical health, your mental health. They ask a lot of questions because one of the things the jail has to do is decide where you're going to be housed. So if you're ill, they're going to isolate you. If you're a gang member, you're going to be isolated with your own members of the gang. They're not going to mix you up because that could result in someone being injured or killed. If there's you have other special needs, they're going to put you on a special needs housing unit, for example. So they're going to ask a lot of questions. Um, so generally, those type of general booking questions are exceptions to the privilege. So remember, it does meet the requirements. It is a statement or testimony. They are being compelled because they're in custody. The exception is that generally not going to be used against the person. Now, there is an exception. Sometimes these questions can uh, be used against them. The answers can be used against them. For example, a gang question. When they ask that person if they're affiliated with a gang, they need to know that for institutional security and housing purposes. But sometimes the government tries to use the answer to that question to prove a gang enhancement. So since it's testimony, it's compelled, and that is incriminating, the government is not allowed to use that statement against that person in the criminal case. Now, the institution can use it for housing and security purposes, but not the government cannot use that to prove a gang enhancement in a criminal case. Um, Double jeopardy. Once a person has been tried and convicted and cannot be tried again, then he can be compelled to make a statement. It is testimony. It's being compelled, but it can't be used against the person. It's not going to incriminate the person because he's already been tried and convicted, or even tried and acquitted for that matter. If you're tried and acquitted, same reason, you can't be tried again, then the person could be compelled to make a statement. Sometimes a person is charged with a misdemeanor, the case is dismissed. In California, if you're charged with a misdemeanor, it's dismissed. That misdemeanor case cannot be refiled. If it can't be refiled, then that person can be um, pressured in or coerced to making it. Coerce isn't the right word, but can be compelled to make the statement. That person cannot claim the privilege against self-incrimination. Now, it does meet the requirements. It is testimonial. It is incriminating. And well, it actually strike that. It's not incriminating. It is testimonial. It is being compelled, but it isn't incriminating. The reason why it's not incriminating is because the misdemeanor case has been charged. It's been dismissed. He cannot be recharged, so it's not going to incriminate him. Therefore, he has to make the statement, right? If a person is given immunity for testimony, then he can't claim the fifth. And immunity comes from it's granted by the court at the request of the government, the prosecutor. The defendant cannot ask for immunity. The government can, and if the court grants it, then he's going to have to make the statement. Because why? He can't be prosecuted for his testimony because he's been given immunity from prosecution. And then also related to that is a plea agreement. So the defendant, for example, enters a plea agreement to cooperate with the prosecutor and will agree to testify. So it is testimony. Um, it is compelled because he's being subpoenaed to testify, but it's not going to incriminate him because they made a plea agreement that he would not be prosecuted. So it's really similar to immunity. Immunity is given by the court. The plea agreement is with the prosecutor, but the same principle. It's not going to be incriminating because there's an agreement or immunity from prosecution. So. How do you invoke the privilege against self-incrimination? Well, custodial interrogation about an uncharged crime, that triggers Miranda, right? We already talked about that. So if you're in custody, you're going to be interrogated about an uncharged crime. The officers, the government has to advise that person of his rights pursuant to Miranda. You have the right to remain silent. Anything you say can be used against you. You have the right to a lawyer. If you can't afford to hire a lawyer, one will be appointed to represent you free of charge. You can exercise these rights at any time. So the person can just simply invoke his privilege against self-incrimination. He can simply say, well, I'm going to remain silent. I'm not going to talk to you. I have nothing to tell you. He invokes his right to remain silent during that custodial interrogation. What about at trial? At trial, the defendant cannot be called by the prosecutor to testify. The defendant is presumed to be innocent. The burden of proof is on the prosecutor to prove the case against the defendant beyond a reasonable doubt. Because he's presumed to be innocent and he has a right not to incriminate himself, the prosecutor cannot call the defendant to testify. So how does the defendant even get on the stand then? Well, during the defendant's case, the defendant may decide, I'm going to take the stand and explain to the jury what happened. A lot of times the prosecutor will present his case in such a way that it really at times forces the defendant to have to take the stand to explain, for example, self-defense. The prosecutor puts on a case showing that the defendant killed the guy, but the only way that self-defense can be established is if the defendant gets on the stand and explains that he was in imminent threat of great bodily injury or death, and therefore the use of deadly force was justified, and he should be acquitted because he acted in self-defense. So sometimes that's the only way. The defendant can get in his evidence to show that he didn't do the crime, or there's some sort of defense to the crime. And then also, what about witnesses? I already mentioned that witnesses can be subpoenaed to court or even volunteer to come to court. And once on the stand, if they're asked questions that may incriminate them, then they can claim the privilege against self-incrimination. That can be very tedious because you go question by question, and the witness has to listen to the question, then invoke the privilege, and the judge has to be paying attention to the question and decide for him or herself if this question tends to incriminate the person, and if it does tend to incriminate the person, then the judge can order the witness not to testify. In other words, uphold that privilege. Or if it doesn't incriminate them, the court can order the witness to testify. So it can be tedious. It's question by question, but the witness can refuse, and the judge can order the person to testify. How does a person waive his rights? Well, it's just the flip side of the coin. During the custodial interrogation, instead of the person invoking the privilege, and instead of the person saying, well, I don't want to talk to you, I want to remain silent, the person can waive his rights and say, yeah, I'll talk to you, and then make a statement. So that's a custodial interrogation. They waive the rights instead of invoking. A defendant will waive his privilege against self-incrimination when he takes the stand and testifies. Now, he will testify, and the prosecution can cross-examine the defendant just on that limited testimony. Technically, the prosecution cannot go beyond that. That's beyond the scope of his testimony. That would be objectionable by the defense. So the defendant can limit the amount of cross-examination by the prosecutor to just what was covered by the defendant's testimony. And then also, once a witness is on the stand, they're asked questions. If they don't invoke the privilege, then it's waived. They've waived the privilege against self-incrimination. So maybe they're asked a question, and it is somewhat a question, the answer may somewhat tend to incriminate the person. If they don't claim the privilege, then and they answer, then they waive the privilege. So that's kind of how that works. So anyway, the testimonial self-incrimination is it's a short. It's the first part of this chapter, chapter 7. The second part of the chapter, as I stated at the beginning, is on bodily self-incrimination, which is regulated under the Fourth Amendment, and that will be the subject of my next video lecture. So I will let you go. I hope you're doing well. I hope you're enjoying the class. I hope you're working hard. And I hope you're learning something too. So remember, officers have to understand these principles because they, that's part of their job. They need to respect, everybody's individual rights. If they violate their rights, I've already mentioned this. Bad things can happen. The case itself can be compromised if they violate the rights. The officer can get in trouble for violating their rights. But even if, again, if you're not going to enter law enforcement, if that is something you choose not to do, that's fine. But you should always know your rights so you can protect your rights. So just keep that in mind. All right. So take care, and I will look forward to talking to you soon. Bye-bye.